अप्रोच ले
ऑर्डर 11 मान लो,
ये पोडेंटिक अप्रोच ले लें, ये किसने बनाए, किसने बनाए?
सुप्रीम कोर्ट ने।
कब?
1980।
सुप्रीम कोर्ट क्या होती है? नहीं, हैंग ऑन, इफ यू गो इनटू दैट अप्रोच, सुप्रीम कोर्ट क्या होती है बताइए?
All the chief justice and the judges
sitting at home? No way. No, but if you're going to go that route, then you can even say these are what is they say Supreme Court can make, not administrative meeting of the judges of the Supreme Court. Where does the Constitution provide for administrating of the judges of the court? So we don't want to just destroy the entire system of governance. So did we sit in a court of law? Did we pass a judgment? How did these rules get enacted? Did people have a say in the matter? Or 10, 15, 17 people, then all gentlemen got together in a closed room and say, here, where is the concept of an administrative thing? That administrative concept itself is created by the rules. So it surely cannot supplant the Constitution itself. It says the Supreme Court. It's very clear. Now, I'm not really understanding. I am only concerned with one and only one thing. What have we taken away from Khwaja Sahab, his client, or any citizen of Pakistan? What have we taken away? What have you taken away? If you've taken away something, we will strike it down. I mean, I don't know why we are having this academic discussion. I really don't understand the point.
My Lord, if I may. Now, there is this provision under this law, and Section 7, for example, application for fixation of urgent matters. Do we not know that there are people who died in prisons, condemned to death before their appeals came up for hearing?
This is our domestic affair.
No, with great respect, my Lord, it is not.
It is.
Absolutely not, my Lord, with great respect. This is the right of the litigants ka right hai.
Learned Attorney General.
My Lord, with great respect, it is not.
Resolve this.
It can't possibly.
Learned Attorney General, what if the Chief Justice refuses to call a meeting of the full court and refuses the full court to amend the rules? Should the Parliament not intervene in the interest of the litigants? That is exactly what has happened.
And here, if my Lords may kindly turn to Order 11 of the Supreme Court rules. Order 11 of the Supreme Court rules. I'm just going to take this point forward. Order 11 of the Supreme Court rules. It begins by saying, save as otherwise provided by law. The full court, going by, let's say...
एक मैं आपको इसमें तसादुम दिखा दूं अब मौजूदा रूल्स में जो आइन से तसादुम रखती है, ठीक है? अपील इज अ राइट, सिविल पिटिशन फॉर लीव टू अपील इज नॉट अ राइट. फॉर एन अपील the rules provide 30 days, which is a right. For a civil petition for a leave to appeal, you get lots of time, 60 days. I would say it violates the very concept of the Constitution. Maybe it's a mistake, but the other question would be, can these rules be challenged? I think they can be challenged. If they had a supra-constitutional effect, they can't be challenged. Suppose I refuse to, suppose tomorrow I refuse to fix any bench. What will compel me? At the moment there is stay order of reason, I said, nahi, hum chutti pe jaate hain, hum court hi nahi lagate hain. What will you do? Move a reference against me, that's about all. You can't compel me under any law to do that. So, the object is, there has been a problem, there has been successive addition of cases, we are completely closing our eyes to it. हम 2019 में full court meeting हुई थी, वो भी हम नहीं कॉल कर सकते हैं, वो भी इख्तियार चीफ जस्टिस का है. 2019 से 4 साल गुजर गए हैं, क्यों नहीं मीटिंग कॉल हो रही है? 2019 से उस जमाने में 40,000 केसेस थे, अब उसमें ऐड हो गए 27,000. हमारी मर्जी, हमारा डोमेस्टिक अफेयर है? नहीं, हमारा डोमेस्टिक अफेयर है, फिर हम तनख्वाह नहीं लें स्टेट से. हम टैक्स पेयर हमें पैसे देता है, हमें एक काम के लिए पैसे देता है, केस का फैसला करो, ये हमारा काम है और कोई काम नहीं है, बाकी सारे हमारे पेरिफेरल काम है. तो ये आप इतने आप उस मेन पॉइंट पे आप नहीं रह रहे हैं, आप भी खिसक रहे हैं उधर, वो भी मेन पॉइंट पे नहीं आ रहे हैं.
माय लॉर्ड आई जस्ट
जो आप पढ़ रहे थे कॉन्स्टिट्यूशन ऑफ बेंचेस का, इसको पढ़े ना, ये सेव एज अदरवाइज प्रोवाइडेड बाय लॉ.
जी,
तो कोई लॉ था नहीं
जी, उस वक्त नहीं था. रिकग्निशन थी कि लॉ प्रोवाइड कर सकता है कुछ
नहीं. आपसे ये अभी देखिए,
उस वक्त लॉ नहीं था.
अब ये लॉ, क्या ये आपके ख्याल में ये जो 1980 के रूल्स हैं, ये लॉ है?
My lord, these are
आपसे simple. Are the 1980 rules law come within the purview of law or
191 की definition क्या आप
Article 191.
No, sir.
no?
No.
These are the rules.
These are the rules. The
But
language
it is-
says subject to the and the law, the
See,
Supreme
but
Court will make rules.
what is the purpose of mentioning save as otherwise provided by law?
Yes, this is the recognition of what Article 191 provided. Now, at that time, there was no statute or an act of parliament which provided for anything, but the
You
full
mean to say
court of
that
this
now
court left it
law-
open.
Now the law has been
Knowing,
promulgated and this covers under this provision.
yes, not just this provision, it is covered under 191. This only recognizes what 191 already.
Mr. Attorney General, then you are excluding all those laws which are made under the delegated powers? You are excluding all those laws which are made under the delegation of the power by the government or the parliament? Delegated legislation
In what context, my lord?
in the context of definition of law. The two primary law and the delegated law. And delegated law includes the rules.
No, we are looking at.
The Supreme Court rules are not law.
We are only looking at the language of 191. We are looking at the language of 199 and we are trying to understand what is the term or what is the scope of term law as provided under 191 is.
Yes.
Now, I had taken your lordship through how this provision or the pari materia provision had historically progressed, where in addition to parliament there was a executive as well. That role was taken away, that role was eliminated, but the role of parliament remained. And, my lords, Article 67, which provides for the regulation of the rules of procedure of the houses, there is no such
You have not,
language.
you have not argued on Article 142
मैं
because this
उसकी
is
तरफ
the
हूँ।
distribution of legislative power.
Yes.
And Majlis-e-Shura Parliament shall have exclusive powers to make laws
With respect to
any matter in the federal legislative list.
Yes.
And if we go to Article 50, the legislative list of item 57, it is also related to
58.
58. उसके साथ 55, sorry, 55
yes, it
jurisdiction
is,
and
yes.
power of all courts.
So insofar as Section 5 is concerned, it is entry 55. With respect to other provisions, it is Article 191 read with entry 58.
Article 50,
Could
sorry,
be read
item
Why is it
58.
not coming under 55? It says enlargement of the jurisdiction of
It
the
does.
Supreme
That's
Court
what I said, sir.
and the conferring up there on a supplemental powers. So it
what
has
I
given us
submitted, sir.
more powers. I have committed a mistake. I've given you an exact example of a Himalayan mistake committed by this court, the Recodic Judge. 6.5 billion, isn't that a big enough mistake for us to understand?
That's exactly what I've submitted. Section 5 is covered under entry
So
55.
you are trying to resolve that. Why? I don't know. I mean, they don't argue the case. I don't know why we're not proceeding. We love quoting American presidents. Why don't we quote the American president, which the Supreme Court of America says 20 minutes and nothing more?
My lord.
You are not, please don't take questions. You just hear them, write them down, whatever.
Now, my lord, I just stick to the submission that I had made in the beginning. Mr. Amir Rahman is the person who is recording the question.
Learned Attorney General.
जब आप देखें हम आज से सुबह से कोई 150 केसेस की एडिशन हो गई होगी because of this case. We can hear this case for the next month. No other work will happen in the Supreme Court. If you want the system to collapse, please proceed. Take your time. We won't interrupt. ख्वाजा साहब नाराज हो कहते हैं, अब आप नाराज हो जाएंगे, मुझे बोल नहीं दे रहे हैं. Points ले हम नोट करेंगे. हम आपको सुनने के लिए बैठे हैं. आपने इतनी मोटी चीजें दी, हम पढ़ लेंगे इनको.
Now, I just quickly rush through my submissions and my
Question that in Order 11, the use of the word law, the term law, you think it carries the same meaning as in Article 191?
Yes. Now, my lord, if leaving this act out of the Article 191 would render part of Article 191 redundant where it says subject to law. And redundancy cannot be attributed lightly to a statute, let alone a constitutional provision. The judgments are in the paper book. My lord, there was another submission which was made with regards to field being occupied, which is to say that since the rules had been made, therefore the field stood occupied and therefore a law cannot be made. Now, that principle also does not apply because that principle is only applicable where the powers are coextensive or coterminous. Here, the Constitution specifically says that the rules shall be subject to the Constitution and the law. It can't be. So therefore, the principle of the principle, the doctrine of occupied field does not get attracted here. Now, my lord, if I may take your lordships to the individual provisions of the statute before I conclude my submissions. Section 2, my lord. Section 2, as I've already submitted, it endeavors to create more transparency, where the power has been, which was under the rules vested in the Chief Justice, has now been
Call it a sharing of the burden.
sharing of
It's
the
a
burden.
huge burden.
Yes.
Why think of it negatively? Think of it positively.
My lord-
I don't want this burden. I want to share it with my colleagues. So what?
Fantastic, my lord. That ends the matter as far
No,
as
no,
Section
as
2 is
I'm
concerned.
talking about
Absolutely.
myself.
Absolutely. Absolutely. And because what it does is...
If I don't trust them, that's the only other way. I can't trust them.
It is in this time
trust
when
them 100%.
we want the justice system to be more efficient. It actually helps. There are more minds sitting together trying to work out how to make things more efficient and transparent in order to aid the litigants who come before your lordships. And if I may say so, the primary duty and obligation of this court is under Article 185, exercising appellate jurisdiction. Because the law was suspended, or well, the bill was suspended before it became an act, which was also, if I may say so with regret, was a first. My lord, this is exactly what under subsection 2 the committee is to do as the first.
We will regulate through rules. They will regulate this act through rules.
My lord, the committee will determine its procedure, much the way the Supreme Judicial Council's procedure has also been made. It's not necessarily, I don't know what their relevance, what their status is an SRO or as a rule or whatever they call it, but the committee can determine its procedure and it will be a procedure of the committee for the purpose of its functioning. Now, Section 3, my lord. Section 3 is exercise of original jurisdiction by the Supreme Court. Now, there was a question which was raised and which was asked when the petitioners were arguing that the committee is to first see whether the matter is, it has to come before the committee to determine if there is a question of public importance with reference to enforcement of fundamental rights, and if the committee thinks so, only then it will constitute a bench. And there was a question raised from the bench that would this not be an administrative power controlling a judicial function? And my response to that, my lords, is that if it is determined, it is held that it is an administrative function and it cannot be performed in a manner to control judicial powers, then my lords would surely come to the conclusion that this court will never exercise suo motu powers either, because while exercising suo motu powers, it is either previously it was the Chief Justice who first determined whether the matter was of public importance and relatable to enforcement of fundamental and then constitute a bench. This is this tension which my lord had also while authoring judgment, rendering judgment.
This doesn't
would
answer
be
the question whether the threshold of 184.3 is to be decided by the committee, as this law suggests, or whether it is the function of the court, whether it's a judicial power. That's the fundamental question, that is this not a judicial power? Because there is a threshold, you say so yourself that there's a threshold. So how can a committee be deciding it? And again, it goes to the fact that if the committee decides that doesn't meet the threshold, then the person that has filed the petition, they can't challenge that decision?
My question is,
there's a distinction between
Leonard
what is
Attorney
filed
General.
under 184
Leonard
and suo
Attorney
motu, and that's
General,
why, my lord.
my question is, if the Chief Justice, just one person, as a master of the roster, could decide whether to take a suo motu or not, why not a committee?
Yes, and that is why my response was that
further
if
providing guarantees, and my only question is, are we not accountable to the litigants?
absolutely.
The Parliament is the representative of the litigants. If they want to change our procedure, because they are not satisfied with our internal or institutional independence. That's their prerogative.
And
We are
if I
there
may-
to serve the litigants.
And if I may, my
But
lord.
then normally, you see, the cases would be marked by the Chief Justice, even if it's a 184.3. So I think the question of judicial power is secondary. First comes the constitution of the bench, and then judicial power is going to be exercised. Here we're talking about the constitution of the bench. It doesn't impair any judicial power. The question is, earlier the Chief Justice would mark the case to somebody. He would certainly mark it. I mean, I as a judge would not hear any case unless it's marked to me. And then all it says is that instead of the Chief Justice, the committee marks it.
Section
So
3,
judicial
my
power
lord.
is not in any way impeded because judicial power comes after the bench. is
Section
marked.
3, Section
you
3
see,
talks
Section
about
3
invoking of jurisdiction, and that is what I was addressing.
Specifically states that the committee would examine. देखिए, the word
जी,
used
जी.
is
And that's what I was
examine.
addressing.
After for examination, if the committee is of the view that a question of public.
This is exactly
So
what
it's
the
a
Chief
judicial
Justice-
power.
Yes, yes, yes. So मैं
So
यही
how
कह रहा
can the
हूँ,
committee on the administrative side exercise judicial power?
मैं यही आपको कह रहा हूँ कि if you are minded to hold, कि ये जो overlap हो गया है कि administrative function और judicial function को control कर रहा है, you would have to inevitably hold that going forward there will never be a suo motu exercise of powers, because that's exactly what the Chief Justice to do. They will first examine it and then constitute a bench, और यही वो tension थी जो आप paragraph 53,
Please take
54
one
में आपने
question
कहा
from
था.
this side, AG Sahab.
Oh, sorry.
The Article 184 begins with the word Supreme Court. What does that mean? Supreme Court means all the judges or only the Chief Justice?
It's what Article 176, your ladyship, says is the Chief Justice and the
184
judges of the Supreme Court.
184 I'm talking
जी जी,
about.
तो 184 में जो सुप्रीम कोर्ट है, सुप्रीम कोर्ट को जो है वो 176 से फ्लो करेगी.
जी, जी.
176 में सुप्रीम कोर्ट का मतलब है चीफ जस्टिस एंड ऑल द जजेस.
All the judges.
No single person
Yes.
is the Supreme Court. It's all of you who are the Supreme Court. So while exercising jurisdiction, अब ये हो सकता है कि आप ये कहें कि नहीं, ये सेक्शन 3 जो है ये इस तरह से नहीं होगा, इसको हम रीड डाउन करेंगे और कोई भी एक्सरसाइज सारी कोर्ट बैठेगी और वो पहले देखेंगे कि ये थ्रेशोल्ड मीट होता है या नहीं होता है, and then
You mean to say that-
by committee that could be
General, Mr. Attorney General, the committee is constituted of 3 members to see whether the case do fall within the ambit of 184(3) or not. The litigant would be invited to argue, or that would be only seen by the members of the committee themselves. If 2 out of 3 comes to the conclusion that it is not a case fit for to proceed with Article 184(3), would it not be defiance of right of audience and the Article 10A and all other due process?
इसमें
What, and
General,
in
Mr.
continuation,
Attorney
and what remedy would be available to him, because
but-
this is an administrative order, they cannot be challenged in appeal, except the chamber appeal under the rules.
Mr. Attorney General, Section 3 is not actually saying that he's going to dismiss a petition at the administrative side. It is simply saying we look at the petition as the Chief Justice looks at the petition. He looks at it, it says a 184(3) petition, he marks it to a bench. It is not saying there is no consequence. Suppose he thinks there is no question, he'll mark it to some other bench. It doesn't say he'll dismiss the petition as to give a hearing to anybody. This is just to look at the
My lord,
file
ये जो
and-
threshold है एडमिनिस्ट्रेटिव
Nobody's talking
साइड
about
पे
a
डे
hearing
इन डे
here.
आउट बेसिस पे हमें क्रॉस करना पड़ता है लिटिगेंट्स ऑन दिस साइड,
I'll
जहाँ पे ऑब्जेक्शन आ जाते हैं रजिस्ट्रार के कि जी ये मीट नहीं.
I tell you what's been happening. Number of 184(3) petitions have come up that the office has put objections. Not the judge, the office.
Yes.
जी जी, one very low.
बिल्कुल.
ठीक है, उन्होंने objection लगा दी, not does not come within a
उसके chamber appeal में जाना
ठीक
पड़ता
है. They've come to me some of the absolutely ridiculous kind of petitions. ठीक है, they're dismissed in my chamber against an appeal is filed. The fact that you don't make available 184(3) does not mean you can't file a civil suit, does not mean you can't file an FIR, does not mean you can't go to 199, does not mean any other remedy. So this is done every day, we do it. Not 3 judges, 1 assistant registrar in the branch office says not maintainable, उसके खिलाफ अपील आती है. वो कितने लोग सुनते हैं? 1 जज. उसके खिलाफ की अपील है? कुछ भी नहीं है. End of story. ठीक है, तो यहाँ वो भी जुरिडिक्शन बढ़ गया है। वो आपने हमें वो असिस्टेंट रजिस्ट्रार के पार हमें दे दिए हैं, उसके पास होना चाहिए असिस्टेंट रजिस्ट्रार के पास, तो रहने दें उसके पास, वो बेशक बेहतर तयन कर लेगा, जो खुश नहीं होगा वो अपील में होगा। अब तो ये तो बल्कि ज़्यादा उसको अहमियत दी जा रही है रादर देन उसको निगेट कर रहे हैं। और राइट तो नहीं है 184(3) का, राइट आपके सारे महफूज हैं, जो आइन देता है, जो कानून देता है। ये नहीं कि आपने 184(3) की पिटिशन डिसमिस कर दी, 99 में आप नहीं जा सकते हैं, या आप सूट नहीं फाइल कर सकते हैं, जो भी चीज़। यहाँ तो लोग अजीब अजीब चीज़ें, जी मेरा इससे पैसे उधार हैं, वो जाके 184 डाल दिया उसने, हमने उसको डिसमिस कर दी। रजिस्ट्रार ने राइटली मेंटेनेबिलिटी भी किया, अपील है, हमने उसको डिसमिस कर दिया, इवन दो जस्ट वेस्टेड अननेसेसरी टाइम ऑफ अ जज ऑफ द एंटायर स्ट्रक्चर ऑफ द सुप्रीम कोर्ट। So I don't know what are we taking away? Back to the same question, what are we taking away?
इसमें इस वक्त क्या सिस्टम चल रहा है? 184(3) में सिस्टम क्या चल रहा है?
दो सिस्टम्स हैं। एक है कि जब कोई पिटिशन आती है, जब कोई पिटिशन फाइल होती है तो वो ऑफिस के इससे होके जाती है, रजिस्ट्रार ऑफिस वुड फर्स्ट एग्जामिन वेदर इट मीट्स द थ्रेशोल्ड और नॉट। इनफैक्ट उसके ऊपर जो ऑब्जेक्शंस आते हैं वो कहते हैं कि जी ये नहीं मीट करता, एंड दैट्स द एंड ऑफ द मैटर, यू फाइल अ चेंबर अपील। सो दैट इज वन राउट। द 184(3) का दूसरा है सो मोटो। नाउ this provision, in fact, cures the problems in the process on both counts. First, 184(3) की जो registrar ये power exercise कर रहा था, that power has now been given to this committee, the three senior most, Chief Justice and two senior most judges.
You see, the power of registrar could be appealed in chamber, but in 3 members committee, where the appeal lies.
Which is the 3 judges, my lord.
3 judges.
ये बात ठीक है कि उसमें ये बात हो सकती है कि जी उसकी कोई आपको जो है वो फिर आगे हेयरिंग नहीं होगी, हेयरिंग नहीं होगी, मगर
जी साहब आप ये बता देना कि अगर 2 जजेस या 3 जजेस बेंच चल रहा है, जैसे कि पुराना सिस्टम है, उसमें एक अगर 3 मेंबर्स समझते हैं कि दिस इज केस ऑफ पब्लिक इंपॉर्टेंस, वो रेफर करते हैं ऑनरेबल चीफ जस्टिस को, और चीफ जस्टिस इनकार कर जाता है कि तीनों से एग्री नहीं करता, ही हैज ऑल द पावर, तो सिर्फ 2 मोर पावर, 3 judges sitting in the court. The Chief Justice alone sitting in a chamber can undo this.
And the suo motu particularly, उसमें तो और ज़्यादा फिर problematic है, because उसमें तो खुद ही कर रहे हैं, वो खुद ही एग्जामिन कर रहे हैं।
3 में भी the process is that if the committee thinks that it's a matter of 184(3), they'll mark it to a bench which is not less than 3. If they think it's not, they'll send it to a 2-member bench maybe, or whatever. It's not throwing out the list.
And my lord, as my lord the Chief Justice has just observed, it is not that other than 184(3), the constitution of this country or the laws of this country do not provide any remedy.
May I add to this?
My lord.
All that the committee will be doing, raising an objection.
Yes.
Objection to the effect, and that is for us internally to provide an appeal against that.
Lords can suitably amend the rules and
again, the question is that since 1980 had not amended our rules, that is why the Parliament was forced to amend them. Had we amended them ourselves, because the bars were raising questions, the public was raising questions, the litigants were raising questions, we actually forced the Parliament to do it for us. And everyone, there's consensus that this is exactly, अब इस वक्त हम सिर्फ ये कह रहे हैं कि बहुत अच्छा काम है, पार्लियामेंट ना करती आप कर लेते, but what when we are refusing to do that? And that is exactly what has happened.
Being 43 years.
This act simply says that we've not been doing our job earlier.
That is it.
And it's saying we'll do it for you because you've been sleeping all the time.
You are too polite to say that.
My lord, we have section 4.
Read that actually.
Section 5.
अभी तक जवाब नहीं आया।
जी, वो आपने जो बात कही कि जी अब फुल कोर्ट अगर बैठेगी उसमें उस राइट ऑफ अपील का क्या होगा?
पहले क्वेश्चन तो ये है कि राइट ऑफ अपील कॉन्स्टिट्यूशनल अमेंडमेंट के बगैर कैसे आ सकती है जब 184(3) is a constitutional provision and it specifically it does not provide a right of appeal. Where the right of appeal was sought to be provided, it was provided specifically in the constitution. Aren't you adding to the constitution or amending the constitution without an amendment in the constitution?
Entry 55 says that we'll enhance your jurisdiction तो उन्होंने एक और 84 की अपील बना दी है तो enhance
185 की भी फिर एक और अपील बन सकती है?
बना दें,
बन सकती है। सेकंड अपील तो है, हमें वैसे भी बताया हुआ है हमने कि हम
Speaking for myself, Learned Attorney General, speaking for myself.
Why not then a third appeal or a fourth appeal or a fifth appeal?
It's the Parliament won't do absurd things, and of course,
it's not a question of absurdity, because this undercuts the review, the whole concept of review. The finality of judgments, res judicata, is regarded as one of the most fundamental principles of the administration of justice.
it surely does.
Exception, no, अगर आप बात कर रहे हैं तो ये तो फिर infinity हो गया।
नहीं, infinity नहीं है, obviously, you know, we're talking about the Parliament here, we're not talking about.
आप बात फिर आ जाती है conjecture और theory और ये और वो, बात principle की हो रही है, असूल समझने की है ना। एक दफा एक बात को concede कर दिया जाए, accept कर लिया जाए, in principle then there is no limit. And therefore, if there is no limit, the question to my mind arises that therefore the power does not exist. This is the
Great
point.
respect.
Again, a review jurisdiction भी है ना. Review jurisdiction का क्या concept है कि Supreme Court में finality हो गई. अब आप maximum में review कर लें.
With great respect, when it comes to even on this plane, and I submit that entry 55 sufficiently covers section 5.
Can you go to the next point?
I'll only add to this, Learned General, there's a distinction. Article 185 explicitly is for those judgments that are rendered by the lower courts. Here the appeal has been provided in 184.3, which is our original jurisdiction. And it's only of a supplemental nature. It's a continuation of the same proceedings, the original jurisdiction.
And in a context where this court becomes the first and the final court in the same proceedings.
Are you done?
My Lord, to this extent, and I'm just going to conclude my other two submissions. I have placed on with my paper book the judgments of in Baz Mohammad Kakad case and the Punjab Provincial Cooperatives case. They are in volume 2, my Lord. My Lord, section 6 now, right to...
there was one concern also raised by Justice Aisha Malik, which was that if we follow this procedure, then when the full court meets, then the appeal goes away. एक ये भी point था, इसको आप कैसे address करेंगे? Because I mean, one answer could be if the wisdom of all is such है, तो फिर वो naturally सब लोगों ने सारे angle देखे होंगे, एड्रेस करना चाहते हैं।
उसमें एक ये बात है, मैंने अपने रिटन सबमिशंस में ये कहा है कि आप इसको टू दैट एक्सटेंट रीड डाउन कर लेंगे।
इस हद तक रीड डाउन करें
जहाँ पे फुल कोर्ट होगी, नेचुरली अपील हो जाएगा, बट आप उसको ये कर सकते हैं। सॉरी सर, जस्ट
I'm saying if you harmonize 4 and 5 in a situation where the whole full court is hearing it, the question of appeal does not arise.
My Lord, ये अब 15 बैठे हुए, so मैं so if it was in original proceedings, it was a bench comprising of 7 lordships on this side. The appeal would have come before the remainder.